This chapter concentrates on the Uniform Securities Act's regulations and registration requirements for securities. We will begin by identifying both the investments that do and those that don't meet the definition of a security. You will be required to compare and contrast the various methods of securities registration as well as determine whether a security is exempt from registration. Securities. To identify whether an investment is defined as a security, state and federal authorities often use a four-part test described in the U.S. Supreme Court decision of SEC v. W.J. Howe Co. The four required elements are: 1. An investment of money, if you invest in asset, usually cash, but it could be other assets to buy into a project. 2. In a common enterprise, if you gave money/asset that is pooled with other investors and those assets are tied together to grow. 3. With the expectation of profits, if you invest not because you wanted to use the product, but because you wanted your money to grow. 4. Solely from the efforts of others, mean if you just gave an asset to have someone make that asset grow by using someone else to take care of it. This general definition applies to many different types of investments. The following list represents investments that are considered securities. Stocks, including treasury stocks, rights, warrants, transferable shares, or certificates of deposit for a security, example American Depository Receipts. Notes, bonds, debentures, collateral trust certificates, or other evidence of indebtedness. Interest in any profit-sharing agreement. Variable annuities and variable life insurance contracts. Voting trust certificates, certificates of interest in an oil, gas, or mining title or lease, pre-organization certificates or subscriptions. Investment contracts, including interests in oil and gas drilling programs, real estate condominiums and cooperatives, farmlands, or animals, whiskey warehouse receipts, multilevel distributorship arrangements, and merchandising marketing schemes. Stock options or options on commodity futures contracts. Notice: under the Uniform Securities Act, investment guarantees apply to principal, dividends, and interest because all of them are promised or announced by an issuer. Since capital gains are not outlined explicitly, they're not considered guaranteed under the USA. Since the list is much shorter, it's often easier to remember what doesn't meet the definition of a security. The investment instruments that are not defined as securities include insurance, endowment policies, or annuity contracts under which an insurance company promises to pay a fixed sum of money either as a lump sum or periodically for life or other specified period, i.e., term, universal, or whole life insurance policies, and fixed annuities. Individual retirement accounts, IRAs, or KIA plans. Commodity futures contracts. Currencies. Collectibles. Condominiums, as primary residences. Identifying a security. It's quite common for the Series 66 examination to test a candidate's knowledge of securities by comparing similar types of investment instruments. The following chart has been created to summarize which instruments are securities and which ones are not. According to the Uniform Securities Act. Securities versus not securities. Securities. Stocks, equities. ADRs. Bonds, debentures, certificates of indebtedness, rights. Warrants. Options on stocks. Options on currencies. Options on commodities. Options on futures. Variable life insurance. Variable universal life insurance. Any insurance product that includes the word variable. Viatical settlements, see description on next page. Variable annuities. Investment companies, face amount certificates, unit investment trusts, and management companies. Packaged real estate investments, such as interests in a condominium pool, real estate investment trusts, rights, or real estate limited partnerships. Participation in a profit-sharing agreement, example KIA participation. Investment contracts. Limited partnerships. Whiskey warehouse receipts, multilevel distribution arrangements, merchandise marketing schemes, voting or collateral trust certificates, pre-organization certificates, interests in farmland or livestock. Not securities. Art. Antiques. Other collectibles. Currencies. Commodities. Futures. Term life policies. Whole life policies. Universal life policies. Endowments. Any insurance product that doesn't include the word variable. Fixed annuities, guaranteed contracts. Individual real estate properties and mortgages. KIA plans. IRAs, 401k plans, and other retirement plans. Viatical investments, also referred to as life settlements, represent the purchase of the rights to the death benefit from an individual's life insurance policy. A policyholder who is either ill or in need of cash may sell the right to the death benefit from his life insurance policy at a discount to a viatical company. The company will then in turn sell these interests to investors. An investor may purchase a whole interest in an individual death benefit or a fractional interest. Investors may also purchase interests in pools of viatical settlements that are put together by the company. Viatical investments are considered securities and must be registered in the states in which they're sold. Also, the broker-dealers and agents who sell them must be registered in these states. Under NASAA guidelines, viatical investments are considered risky investments and may only be sold to suitable investors. Suitable investors include any person that meets the definition of accredited investor in Regulation D of the Securities Act of 1933, example bank, broker-dealer, investment company, investment advisor, insurance company, or a natural person whose net worth exceeds $1 million or whose annual income exceeds $200,000 in each of the last 2 years' annual income of $300,000 with spouse or spousal equivalent. Any executive officer, director, or partner of the issuer. Any natural person who individually, or jointly with a spouse, has a minimum net worth of $150,000 and gross income that exceeds $100,000, or has a minimum net worth of $250,000. In both cases, net worth does not include the person's residence. Since death is unpredictable, the rate of return that an investor will receive cannot be calculated until the policyholder dies. In the meantime, investors will not have access to their capital and there's no secondary market. If the policyholder lives longer than expected, investors may need to contribute additional money in order to pay the policy's premiums. Another concern is that investors may not receive anything if either the viatical company or the life insurance company that issued the policy declares bankruptcy. Clearly, the preceding list of investments that are considered securities contains some strange entries. For example, what is a whiskey warehouse receipt? Before answering that question, it may help to know that many of these instruments were added to the definition of a security in response to specific instances of investment fraud encountered by states. Including them as securities allowed administrators to regulate them and potentially stop investment scams that were not originally envisioned by state law. By the way, whiskey warehouse receipts represent a share in a quantity of whiskey being aged for future sale, perhaps 10 or 12 years before bottling. If investors don't want to wait for the product to be sold before cashing out, they might sell their warehouse receipts to other investors. Under state law, the transfer of a whiskey warehouse receipt is equivalent to the delivery of the property it represents, and therefore it constitutes a security. Another seemingly unusual instrument is a real estate condominium. This instrument was added to the list of securities to cover investment opportunities in which the purchaser of a condominium allows his property to be included in a rental pool that's managed by a third party. For example, the condominium might be part of a complex near a ski lodge and the buyer purchases the property for investment purposes, rather than for occupancy. In this situation, offering this type of condominium investment could be viewed as the offer of a security. Multilevel distributorships and merchandising marketing programs are structures used to market products to the public. In the past, these types of programs have occasionally been used to create Ponzi schemes. A Ponzi scheme is a pyramid scheme where returns received by earlier investors are derived from the capital contributed by subsequent investors. Like a chain letter, the fraud typically causes a collapse and results in investors losing money. Due to the negative history of these types of programs, they're defined as securities and are regulated under the USA General Registration Process. Under the USA, it's unlawful for any person to offer or sell a security in a state unless the security is either registered or exempt from registration. Section 401(h) of the Uniform Securities Act, 1956, defines the term issuer as the person who acts as the manager pursuant to the provisions of the instrument under which the security is issued. For example, the Chief Executive Officer, CEO, of a corporation is the business manager, and they would be responsible for registering the corporation's securities. Unlike other securities, oil, gas, or mining leases are not considered to have an issuer under Section 401(h). The rationale behind the difference in oil and mining leases is rooted in the nature of these interests. Unlike traditional securities, these certificates represent fractional interests in the production or revenue from oil, gas, or mineral extraction. If securities related to oil, gas, or mining interests need to be registered, the registration statement can be filed by the person ultimately responsible for the distribution, which is often a broker-dealer or another entity that's involved in the offering. State administrators require registrants to provide general information about the securities being offered, such as the amount of securities to be offered in the state, an adverse ruling entered in connection with the offering by a state regulatory authority, a court, or the SEC, other states in which a registration statement has been or will be filed. Watch out! While the administrator will want to know the other states in which a security will be offered, disclosure of the number of shares being offered in each and every state is not required. Filing fees. Issuers are required to pay filing fees at both the time of initial registration and annual renewal. If either of these fees is not paid, the administrator may issue a stop order, which suspends the sale of the security. The fee will vary from state to state, so there's no specific dollar amount that will be tested on the exam. Effective date of registration. The effective date is the date on which the appropriate regulator releases the security for public distribution. If any securities of the same class are outstanding, a registration statement cannot be withdrawn for 1 year after its effective date unless the administrator determines otherwise. An administrator may also require the filing of quarterly reports by the same person who filed the initial registration statement. The administrator's goal is to keep registration information as current as possible and to monitor the progress of the securities offering. Expiration dates. A securities registration expires 1 year after its effective date. In order to continue to offer or sell the security, it must be re-registered or sold through an exemption. HCI Company's public offering of securities became effective on January 14, 20XX. When will the registration expire? The registration of a security expires 1 year after its effective date, not on December 31. Types of securities registration. In addition to meeting the general registration requirements previously described, each state securities registration must be completed using one of the following 3 methods. 1. Notification, filing. 2. Coordination. 3. Qualification. Registration by filing, notification. This is not notice filing. Registration by notification, also called filing, is used by well-established corporations that meet stringent financial requirements. This method of registration was always reserved for larger issuers with securities that trade on a national exchange and have previously registered with the SEC. Not all states permit the use of registration by filing. However, in those states where it's allowed, the following conditions must be met. 1. A registration statement must have been filed under the Securities Act of 1933. 2. The issuer is organized under the laws of the U.S. or a state, or if not, the issuer has appointed a duly authorized agent in the U.S. for service of process. 3. The issuer has registered with the SEC a class of equity securities that are held by 500 or more persons. 4. The issuer has a total net worth of at least $4 million or a total net worth of $2 million and net pre-tax income for at least 2 of the previous 3 years. Not less than 400,000 units of the class of securities registered under Section 12 of the 34 Act are held by the public, excluding securities held by officers and directors of the issuer, underwriters, and persons beneficially owning 10% or more of that class of securities, and outstanding warrants and options held by the underwriters and executive officers and directors of the issuer in an amount not exceeding 10% of the total number of shares to be outstanding after completion of the offering of the securities being registered. 5. The issuer has been in business for at least 36 calendar months preceding registration. 6. For the issuer's securities registered pursuant to the 34 Act, there must have been at least 4 market makers for a period of at least 30 days during the 3 months preceding filing. 7. The aggregate commissions or discounts received by underwriters may not exceed 10% of the aggregate offering price. 8. The issuer or any subsidiary may not have failed to pay a dividend on preferred stock or have defaulted on any bond or long-term lease since the end of the last fiscal year before it filed the registration statement. 9. In the case of an equity security, the offering price must be $5 per share or more. The application for registration by filing must contain the following information: a statement of eligibility, the issuer's name, address, and form of organization, a statement describing the offering, a copy of the prospectus that has been filed with the SEC. If all or part of the offering is for the benefit of someone other than the issuer, a non-issuer distribution, the statement must also contain the name, address, and amount of securities held by that person, and the reasons for making the offering. Registration by filing becomes effective at the same time as the federal registration, provided no stop order has been entered by the SEC or the administrator. In addition, the required information and documents must have been on file for at least 5 days and the registration fee must have been paid. If the federal registration became effective at an earlier time, the state registration becomes effective when all required conditions are met. Be careful. Some test takers confuse registration by notification, filing, with notice filing. Although both use the word filing, notice filing is not a registration method. We will discuss notice filing shortly. Remember, for registration method, it spells the complete word of notification. The Uniform Securities Act, which was widely adopted in 1956, referenced the provisions for registration by notification. However, all mention of this form of registration has been eliminated in the revised Uniform Securities Act of 2002. Notification has rarely been used in recent years because most securities to which it was applicable are now considered federal covered securities and are able to simply complete a notice filing. Since not all states have adopted the revised USA, the exam may continue to test on the details regarding registration by notification, filing. Notice filing means I'm already registered federally, and I'm just giving the state a heads up, a notice, that I'm doing business there. When a firm has already completed registration by notification, filing. Notes. Registration by notification equals a shortcut into state registration because they are already registered by filing documents, meeting certain criteria, rather than going through full state review. But it is a form of registration. Notice filing equals not registration at all. It just means that we are already SEC registered, federal covered, advisor notifying state of their presence. The state is not granting them anything because they have already registered by filing documents. Registration by coordination. A security may be registered by coordination if the same offering is being registered under the Securities Act of 1933. While the state registration statement is coordinated with the federal registration, it doesn't need to be filed at the same time. Under coordination, a registration statement must be filed with the administrator along with 3 copies of the latest prospectus that were filed with the SEC. The administrator may also request a copy of the Articles of Incorporation, any underwriting agreement or indenture related to the security, or other information or documents the administrator deems appropriate. Any amendments to the federal prospectus must also be forwarded to the administrator promptly. Registration by coordination becomes effective at the same time as the federal registration, provided no stop order has been entered by the SEC or the administrator. The registration statement must be on file with the administrator for at least 10 days. Furthermore, a statement of the minimum and maximum offering prices, maximum underwriting discounts, and commissions must have been on file with the administrator for at least 2 business days. If the federal registration becomes effective prior to the satisfaction of all of the requirements of previous paragraph, the state registration will become effective once the requirements have been met, unless otherwise waived by the administrator. Registration by qualification. Registration by qualification is used when either a security's federal registration has already become effective or when no federal registration will be filed, as is the case for intrastate offerings. The process of registering a security by qualification is much more involved than both the filing and coordination methods. The following disclosures are required under registration by qualification. 1. Information about the issuer and any significant subsidiary, including its name, address, form of organization, the state or foreign jurisdiction in which it operates, and the general competitive conditions in the industry or business in which it is or will be engaged. 2. Information on all officers or directors of the issuer including their name, address, principal occupation for the last 5 years, and the amount of securities they're holding within 30 days of the filing of the registration statement. 3. Information on any person who owns 10% or more of any class of the issuer's outstanding shares, similar to the information required for officers and directors. 4. For any non-issuer distributions, the name and address of the person on whose behalf the offering is to be made, the amount of securities owned, and a statement of their reason for making the offering. 5. A description of the issuer's capitalization and long-term debt. 6. The type and amount of securities to be offered, the price of the securities, estimated selling fees, and underwriting agreements. 7. The estimated cash proceeds to be received and the purposes for which the proceeds will be used. 8. A copy of every prospectus, letter, advertisement, or other literature to be used in connection with the offering, and a legal opinion if it's a debt offering. 9. A recent balance sheet and a profit and loss statement for each of the last 3 years. 10. Any additional information required by the administrator. One of the unique characteristics of registration by qualification is that the registration becomes effective only when determined by the administrator. Remember, although the effective date for securities registered by notification, filing, and coordination is based on the effective date of the issuer's federal registration, this is not the case for registration by qualification. All registration statements are effective for at least 1 year from their effective date. Denial, suspension, and revocation of registration. Administrators have the authority to issue a stop order to deny, suspend, or revoke a registration. These actions may be taken if they find it to be in the public interest and if any of the following conditions apply. A registration statement is incomplete, false, or misleading in any material respect. A provision of the Uniform Securities Act or any rule or order imposed by an administrator has been willfully violated in connection with the offering by the issuer, any partner, officer, director, or control person, or underwriter. Any officer of the issuer or underwriter has been convicted of a crime involving securities. The issuer's enterprise or method of business includes activities that are illegal. The offering is fraudulent, or is made on terms that are unfair, unjust, or inequitable. The seller's compensation is unreasonably large. The registrant fails to pay the proper filing fee, the administrator may enter a denial order which will be vacated when the deficiency is corrected. Administrators may not deny, suspend, or revoke a registration solely based on an issuer's weak financial condition. In addition, administrators may not institute a stop order proceeding against a registration based on facts of which they were aware when the registration became effective, unless the proceedings are instituted within 30 days. An administrator may summarily postpone or suspend a registration pending final determination of any proceedings being conducted under this section. If administrative action is taken, the registrant must be provided with prior written notification and be allowed to submit a written request for a hearing, which must be held within 15 days of the request. Registration exemptions. When a security is not required to be registered, it's classified as an exempt security. Issuers often prefer to offer securities under an exemption because it's more time and cost effective than going through the formal registration process. Under the USA, provisions exist for exempt securities and exempt transactions which are based on the method by which the security is offered or sold. When an exemption for a security or a transaction is claimed, the burden of proof rests with the person requesting it. Both exempt securities and exempt transactions are exempt from registration requirements. However, there's no exemption from the anti-fraud provisions of the Uniform Securities Act. A security may be exempt from registration under federal law, but not state law, and vice versa. When the rules overlap, the most restrictive rule will apply. However, an exemption from registration doesn't exempt a security from federal and state anti-fraud provisions. All securities and persons are subject to the anti-fraud provisions. Exempt securities. Securities that qualify as exempt securities retain their exemption both when initially issued as well as in subsequent trading. Exempt securities include securities issued by the U.S. government and municipalities including debt issued by government agencies as well as states, counties, or school districts. Securities issued by the Canadian government and municipalities including debt issued by provinces or cities. Securities issued by other foreign governments provided the U.S. maintains diplomatic relations with the foreign country and the securities being issued are recognized as a valid obligation of the issuer. Securities issued by banks, savings institutions, or trust companies. Securities issued by federal credit unions or industrial loan associations. Securities issued by insurance companies. This exemption doesn't apply to issuing variable annuities. Securities issued by common carriers, railroads, and public utility holding companies. Regulation of common carriers is performed by the Interstate Commerce Commission, ICC, while utility companies are regulated under the Public Utility Holding Company Act of 1935. Securities issued by not-for-profit organizations. This includes religious, educational, fraternal, charitable, social, athletic, trade, and professional associations. Any promissory notes, drafts, bills of exchange, or bankers' acceptances maturing in no more than 9 months, issued in denominations of $50,000 or more, and rated in one of the 3 highest rating categories by a nationally recognized statistical rating organization, NRSRO. Any investment contracts issued in connection with an employee's stock purchase, savings, pension, and profit-sharing or similar benefit plan if the administrator is notified in writing at least 30 days before the inception of the plan. Federal Covered Securities. Federal Covered Securities. As created by NSMEA and defined under the Uniform Securities Act, these securities are not required to be registered at the state level. Federal rules eliminate a state's ability to regulate the public offerings, proxy solicitations, and periodic disclosures of the issuers of federal covered securities. Although no federal covered security is required to register with a state administrator, certain securities that fall in this category are required to notice file. For now, it's important to know the characteristics of the various types of federal covered securities. Exchange-listed securities, securities that are, or on completion of the offering will be, listed on any exchange including, but not limited to, the New York Stock Exchange, NASDAQ, the American Stock Exchange, and the Chicago Stock Exchange. The exemption extends to securities that are equal to or higher in seniority to the listed security, as well as rights and warrants to purchase the subject security. These securities were previously exempt under a provision referred to as the blue chip exemption. Securities sold to qualified purchasers, as defined under the Investment Company Act of 1940, are persons who own at least $5 million in investments. These sophisticated investors are deemed to be capable of evaluating investments and protecting themselves in a manner that renders regulation by state authorities unnecessary. Investment companies, investment company securities, example mutual fund shares, are registered under the Investment Company Act of 1940 and are also required to be registered with the SEC under the Securities Act of 1933. Securities issued pursuant to Regulation D Rule 506, issuers using the Rule 506 private offering exemption are able to raise an unlimited amount of money. Selling restrictions are imposed on the types of investors that may be involved. However, issuers may use general solicitation or advertising to market the securities. Notice filing. Notice filing refers to a state's demand that certain issuers of federal covered securities satisfy state requirements such as signing a consent to service of process, paying a filing fee, and possibly filing with an administrator any copies of material that has been filed with the SEC as a part of the issuer's federal registration. Notice filing is required for issuers of investment company securities as well as issuers that distribute their securities pursuant to a Rule 506 private placement. The following chart provides a summary of the registration and notice filing requirements for federal covered securities. Remember, unless securities are exempt, they must be registered at the state level by means of notification, filing, coordination, or qualification. Exempt transactions. Another way for securities to avoid state registration is through one of the various exempt transactions. Under the USA, an exempt transaction is a method through which an exemption is provided based on how the security is offered or sold. For transactions, the exemption must be established on a trade-by-trade basis. Since the following list is quite extensive, no student is expected to memorize all of the exemptions. Instead, the best approach is to focus on key terms or themes within the list. The transactions that are exempt from the registration requirements of the USA include any isolated, infrequent, non-issuer transaction, regardless of whether it's effected through a broker-dealer. This covers any secondary market transaction between parties that are not affiliated with the financial industry. Any non-issuer transaction by a registered agent of a broker-dealer provided the issuer is actually engaged in business. This means that the issuer may not be in the organizational stage, in bankruptcy, or in receivership. Also, it may not be a blank check, a blind pool, or a shell company whose primary purpose is to engage in mergers or acquisitions. The securities must be senior to the issuer's common stock. The securities must have been outstanding for at least 3 years and the issuer may not have defaulted on any of its obligations during this time. Or, the securities have been in the hands of the public for at least 90 days and the price is reasonably related to the security's current market price and the securities are not part of the underwriter's original allotment that it failed to sell and information about the issuer is publicly available either through documents filed with the SEC or through a nationally recognized securities manual designated by the administrator and the issuer's stock is traded on one of the exchanges, or the issuer is a unit investment trust registered under the Investment Company Act of 1940, or the issuer has been in business continuously for at least 3 years, or the issuer's total assets equal at least $2 million. A non-issuer transaction in outstanding securities by a registered agent of a registered broker-dealer provided that the issuer is a reporting issuer in Canada together with its provinces and territories, or designated by rule or order of the administrator, and has been subject to continuous reporting requirements in such foreign country for not less than 180 days before the transaction. The security is listed on the Toronto Stock Exchange, the TSX Venture Exchange, or designated by rule or order of the administrator, or is a security of the same issuer, which is substantially equal to or senior in rank to such listed securities or is a warrant or right to purchase or subscribe to any of the previously mentioned. Any non-issuer transaction in a security of a company that's subject to the registration and reporting requirements of the Securities Exchange Act of 1934, or is registered under the Investment Company Act of 1940, or has filed information with the administrator that's substantially the same as that which is required for registered issuers by the Securities Exchange Act of 1934 for a period of at least 180 days prior to the transaction. Any non-issuer transaction effected through a registered broker-dealer on an unsolicited basis. The administrator may require that the client acknowledge on a specified form that the order was unsolicited and that the broker-dealer maintains the form for a prescribed period. Remember, the language of the USA can be tricky. Soliciting the sale of unregistered, exempt securities is permitted because the securities are exempt. However, soliciting the sale of unregistered, non-exempt securities is prohibited. Any transaction between an issuer and an underwriter. Any transaction in a bond secured by a real estate mortgage or deed of trust, provided that the entire mortgage or deed of trust, together with the bonds, are offered and sold as a unit. Any transaction by a fiduciary such as an executor, administrator, sheriff, marshal, trustee in bankruptcy, guardian, or conservator. Any transaction by a bona fide pledgee if the sale is not for the purpose of evading rules of the USA. Any sale or offer to an institutional investor such as a bank, savings institution, trust company, insurance company, investment company, pension, or profit-sharing trust, or to a broker-dealer. A private placement transaction provided it's directed to no more than 10 retail, non-institutional, investors and the following conditions are met. A. The seller believes that all of the non-institutional buyers are purchasing for investment purposes only. B. No commissions or other remuneration is paid for soliciting any non-institutional buyer. C. Form D is filed with the SEC and the state administrator. Any sale of a pre-organization certificate provided that A. No commission is paid for soliciting any buyer. B. The number of subscribers doesn't exceed 10, and C. No payment is made by any subscriber. Any transaction involving existing security holders of the issuer, including persons holding convertible securities and warrants, if no commission or other remuneration is paid for soliciting buyers, or the issuer files a notice specifying the terms of the offer, and the administrator doesn't disallow the exemption within 5 days. Any offer, but not a sale, of a security for which a registration statement has been filed under the Uniform Securities Act and the Securities Act of 1933, provided that no stop order is in effect. Sales may only take place after the registration is effective. Again, try to focus on keywords or phrases when attempting to identify whether an exemption applies. For exam purposes, remember the terms non-issuer, fiduciary, isolated, private, or unsolicited. Also, pay attention to phrases such as trades between issuer and underwriter, trades with institutional investors, directed to no more than 10 retail clients, or not involving the public. The reason that most non-issuer transactions are exempt is because they represent secondary market trades that will be regulated at the federal level. On the other hand, when the issuing entity is in a position to receive the proceeds of the distribution, example an IPO, it's considered an issuer transaction. Issuer transactions may be subject to state registration. The administrator may deny or revoke any exemption upon prior written notice to all interested parties. If action is taken, the administrator must offer the opportunity for a hearing and provide written findings of fact and law. Pending a final determination of any proceedings, the administrator may deny or revoke the exemptions. Acme Incorporated is planning to expand its business and is in need of additional capital. Acme's financial advisors recommend that it offer shares of the company to the public. Are the securities being offered by Acme required to be registered, and what role does Acme play in the offering? Since there's no indication of an exemption, Acme, as the issuer, is required to register the securities prior to offering them to public investors. Generally, when public investors are involved, registration is required. Consider another example of securities registration. A corporation is offering its stock only in California. If the company's stock will be listed on NASDAQ, what method of state registration will the corporation use? Since the corporation is offering its stock only in California, it may seem that the intrastate method of registration, qualification, will be used. However, since the corporation will be listed on NASDAQ, it's not required to register at the state level. Summary of exemptions from state registration. Exempt securities versus exempt transactions. Exempt securities. Securities issued by the U.S. government, agency of the U.S. or any municipality, i.e., state, county, school district, etc. Securities issued by the Canadian government including any state, province, or local Canadian municipality. Securities issued by any other foreign government with which the U.S. maintains diplomatic relations. Securities issued by banks, savings institutions, or trust companies. Securities issued by federal savings and loan associations, federal credit unions, or any security of a similar association. Securities issued by insurance companies. Securities issued by railroads, common carriers, or public utility holding companies that are subject to specified regulations. Securities issued by not-for-profit organizations such as religious, educational, fraternal, charitable, social, athletic, or trade and professional associations. Any promissory note, draft, bill of exchange, or banker's acceptance meeting certain requirements. Any investment contract issued in connection with an employee stock purchase, savings, pension, profit sharing, or similar benefit plan meeting certain requirements. Federal covered securities. Securities listed on a national exchange, blue chip. Securities sold to qualified purchasers under the Investment Company Act of 1940. Investment company securities. Securities issued pursuant to Rule 506. Exempt transactions. Any isolated, infrequent, non-issuer transactions. Any non-issuer transaction by a registered agent of a broker-dealer, provided that the issuer is actually engaged in business. Any non-issuer transaction in a security of a company that's subject to the registration and reporting requirements of the Securities Exchange Act of 1934 for at least 180 days. Any non-issuer transaction effected through a registered broker-dealer on an unsolicited basis. Any transaction between an issuer and an underwriter. Any transaction in a bond secured by a real estate mortgage or deed of trust. Any transaction by a fiduciary, example executor, administrator, or sheriff. Any transaction by a bona fide pledgee if the sale is not for the purpose of evading the Uniform Securities Act. Any offer or sale to various financial or institutional buyers. Any transaction directed to no more than 10 retail, non-institutional, investors, private placement. No commissions may be paid. Any sale of a pre-organization certificate. Any transaction involving existing security holders of the issuer, including persons holding convertible securities and warrants. Any offer, but not a sale, of a security for which a registration statement has been filed under the Uniform Securities Act and the Securities Act of 1933, pre-organization certificate. Note, this chart is simply a summary. Please review the full descriptions in this chapter. Chapter Summary 2. Now that you've completed this chapter, for the following commonly tested concepts, you should be able to use the 4-part Howey test to define a security. 1. An investment of money. 2. In a common enterprise. 3. With the expectation of profit. 4. Solely from the efforts of others. Describe a viatical investment as well as recognize and understand their risks. Understand who pays filing fees and when they're required. Understand what the effective date means for an issuer and who declares the effective date. Identify when the state registration of a security expires. Recognize the differences in the 3 types of securities registration under the USA. Notification, filing. Coordination. Qualification. Understand the reasons for an administrator denying, suspending, or revoking the registration of a security. Recognize the securities that are exempt under the USA. Identify the federal covered securities and which are required to notice file. Understand the characteristics of notice filing. Recognize the transactions that are exempt under the USA.